Chapter 2, Rule 110. How are criminal actions prosecuted?
Part 1. Institution of criminal actions.
The purpose of a criminal action, in its purest sense, is to determine the penal liability of the accused for having outraged the state with his crime, and, if he be found guilty, to punish him for it. In this sense, the parties to the action are the people of the Philippines and the accused. The offended party is regarded merely as a witness for the state, heirs of Sarah Marie Palma Burgos vs. Court of Appeals. How criminal actions are instituted? 1. The institution of a criminal action generally depends upon whether or not the offense is one which requires a preliminary investigation. Where a preliminary investigation is required, a criminal action is instituted by filing the complaint with the proper officer for the purpose of conducting the requisite preliminary investigation. 2. Where a preliminary investigation is not required, a criminal action is instituted in either of two ways. By filing the complaint or information directly with the Municipal Trial Court and Municipal Circuit Trial Court, or by filing the complaint with the Office of the Prosecutor. Institution of criminal actions in Manila and other chartered cities. In Manila and other chartered cities, a special rule prevails. In these places, the rule is that the complaint shall be filed with the Office of the Prosecutor unless otherwise provided in their charters. No direct filing in the Regional Trial Court and Metropolitan Trial Court of Manila and other chartered cities. 1. There is no direct filing of an information or complaint with the Regional Trial Court under Rule 110 because its jurisdiction covers offenses which require preliminary investigation. A preliminary investigation is to be conducted for offenses where the penalty prescribed by law is at least 4 years, 2 months, and 1 day, Section 1, Rule 112, Rules of Court. The Regional Trial Court has jurisdiction over an offense punishable with imprisonment of more than 6 years, a period way above the minimum penalty for an offense that requires a preliminary investigation. On the other hand, the Municipal Trial Court has exclusive jurisdiction over offenses punishable with imprisonment not exceeding 6 years. 2. There is likewise no direct filing with the Metropolitan Trial Court of Manila because in Manila, including other chartered cities, the complaint, as a rule, shall be filed with the Office of the Prosecutor, unless otherwise provided by their charters. Although in Manila and other chartered cities the complaint shall be filed with the Office of the Prosecutor, in case of a conflict between a city charter and a provision of the Rules of Court, the former, being substantive law, shall prevail. Effect of the institution of the criminal action on the prescriptive period, bar 1993. The present rule categorically provides that the institution of the criminal action shall interrupt the period of prescription of the offense charged unless otherwise provided in special laws. Since one way of instituting a criminal action is by filing a complaint with the proper officer for the purpose of conducting the requisite preliminary investigation for offenses where a preliminary investigation is required, the filing of the complaint with the proper officer for such purpose, would, under the rules of court, interrupt the period of prescription. The exception is when a different rule is provided for in special laws. For offenses where a preliminary investigation is not required, the filing of the information or complaint directly with the Municipal Trial Courts and Municipal Circuit Trial Courts, or with the Office of the Prosecutor, shall likewise interrupt the period of prescription of the offense charged because it is a mode by which a criminal action is instituted under Section 1 of Rule 110, unless of course, there be a special law which provides otherwise. In Manila and other chartered cities, the filing of the complaint with the Office of the Prosecutor shall also operate to interrupt the period of prescription of the offense charged, unless also provided otherwise in special laws. Illustration of the above rules. 1 case which is illustrative of the rule on the effect of the institution of the criminal action on the prescriptive period of the offense charged is People vs. Bautista, a case involving physical injuries. Here, the Supreme Court did not agree with the view of the Court of Appeals and of the respondent that upon approval of the investigating prosecutor's recommendation for the filing of an information against respondent, the period of prescription began to run again. It is a well-settled rule, declared by the court, that the filing of the complaint with the fiscal's office suspends the running of the prescriptive period. The proceedings against respondent were not terminated upon the city prosecutor's approval of the investigating prosecutor's recommendation that an information be filed with the court. The prescriptive period remains told from the time the complaint was filed with the Office of the Prosecutor until such time that respondent is either convicted or acquitted by the proper court. 2. The issue as to when the prescriptive period of an offense is interrupted has been the subject of various contending views interpreting some laws relating to prescription, particularly Articles 90 and 91 of the Revised Penal Code and Act No. 3326 as amended. 3. The diversity of opinions started with the interpretation of Article 91 of the revised Penal Code, which partly provides the period of prescription shall commence to run, and shall be interrupted by the filing of the complaint or information. The early case of People v. Taco ruled that the complaint or information referred to in Article 91 is the one filed in the proper court and not the denuncia or accusation lodged by the offended party before the fiscal's office or with the Justice of the Peace Court for preliminary investigation. Arrayed against the ruling in Taco are the opposite views expressed in various decisions which consider the filing of the complaint before the municipal judge for preliminary investigation as sufficient to interrupt the prescriptive period for the offense. Taco was not followed in the subsequent case of People v. WILLARD, where the court ruled that the filing of the complaint with the Justice of the Peace for preliminary investigation interrupted the running of the statute of limitations. In the other case of People v. WILLARD, the rule became more clear. The court in WILLARD gave the following justifications for its ruling. First, the words "shall be interrupted by the filing of the complaint or information" does not distinguish whether the complaint is filed in court merely for preliminary investigation or for action on the merits. Second, the filing of the complaint for preliminary investigation already represents the initial step of the proceedings against the offender. Third, it is unjust to deprive the injured party of the right to obtain vindication on account of delays that are not under his control. The pronouncements in WILLARD were subsequently confirmed in Francisco v. Court of Appeals, to be the true doctrine. Thus, the filing of a denuncia or complaint for intriguing against honor, changed later to grave oral defamation, even in the fiscal's office, interrupts the period of prescription. Quoting WILLARD, the court in Francisco held that after re-examining the question and after mature consideration, the court has arrived at the conclusion that the true doctrine is, and should be, the one established by decisions holding that the filing of complaint in the municipal court, even if it be merely for purposes of preliminary examination or investigation, should, and does interrupt the period of prescription of the criminal responsibility, even if the court where the complaint or information is filed cannot try the case on its merits. Rule on prescription for violations of special laws and municipal ordinances. 1. Act No. 3326 as amended, is the law which governs the period for prescription for violations penalized by special acts and municipal ordinances. Zaldivia v. Reyes, a case involving an offense punishable by a municipal ordinance, held that when that respondent's Remedial trading in Tutuban Center, Manila was selling imitations of petitioner's products. Upon application by the petitioner, a search warrant was duly issued. On the same day the warrant was issued, agents of the NBI searched the premises of Remedial trading and seized various Sanrio products. The petitioner, Sanrio, filed a complaint affidavit with the Task Force on Anti-Intellectual Property Piracy, TAP, of the Department of Justice, DOJ, against respondent for violation of Section 217, in relation to Sections 177 and 178, of the Intellectual Property Code, IPC. The TAP dismissed the complaint due to insufficiency of evidence. The petitioner's subsequent motion for reconsideration was denied. Hence, it filed a petition for review in the Office of the Chief State Prosecutor of the DOJ. The Office of the Chief State Prosecutor affirmed the TAP's resolution and the petition was dismissed for lack of reversible error. Aggrieved, the petitioner filed a petition for certiorari in the Court of Appeals, which likewise dismissed the petition, among others, on the ground of prescription. It based its action on Cs. 1 and 2 of Act 3326, which state: Section 1. Violations penalized by special acts shall, unless otherwise provided in such acts, prescribe in accordance with the following rules: a. After a year for offences punished only by a fine or by imprisonment for not more than 1 month, or both; b. After 4 years for those punished by imprisonment for more than 1 month, but less than 2 years; c. After 8 years for those punished by imprisonment for 2 years or more, but less than 6 years, and d. After 12 years for any other offense punished by imprisonment for 6 years or more, except the crime of treason, which shall prescribe after 20 years, provided, however, that all offenses against any law or part of law administered by the Bureau of Internal Revenue shall prescribe after 5 years. Violations penalized by municipal ordinances shall prescribe after 2 months. Section 2. Prescription shall begin to run from the day of the commission of the violation of the law, and if the same may not be known at the time, from the discovery thereof and the institution of judicial proceedings for its investigation and punishment. The prescription shall be interrupted when proceedings are instituted against the guilty person, and shall begin to run again if the proceedings are dismissed for reasons not constituting jeopardy. The Court of Appeals ruled that because no complaint was filed in court within 2 years after the commission of the alleged violation, the offense had already prescribed. The petitioner disagreed, and in the Supreme Court, petitioner averred that the Court of Appeals erred in concluding that the alleged violations of the Intellectual Property Code, IPC, had prescribed because it had actually filed a complaint with the corresponding task force of the DOJ. It contended that said filing told the running of the prescriptive period for the offense. The Supreme Court found the contention meritorious. It likewise confirmed that under Section 2 of Act 3326, the prescriptive period for violation of special laws starts on the day such offense was committed and is interrupted by the institution of proceedings against respondent, i.e., the accused. It also found that the petitioner in this instance filed its complaint affidavit with the TAP of the DOJ before the alleged violation had prescribed. The court categorically ruled that the prescriptive period for the prosecution of the alleged violation of the IPC was told by petitioner's timely filing of the complaint affidavit before the TAP. 3. In Panganiban, Jr. v. DOJ, the issue raised was whether or not the filing of a complaint for violation of BP 22 before the office of the prosecutor interrupts the running of the prescriptive period for the offense. Here, the assistant city prosecutor dismissed the complaint against the respondent because the case had already prescribed pursuant to Act No. 3326, as amended, which provides that violations of laws as those penalized by BP 22 shall prescribe after 4 years. Accordingly, the 4-year period started on the date the checks were dishonored, and the filing of the complaint before the case on city prosecutor did not interrupt the running of the prescriptive period, as the law contemplates judicial, and not administrative proceedings. Thus, considering that more than 4 years had already elapsed from the dishonor of the check and no information had as yet been filed against the respondent, the alleged violation of BP 22 imputed to him had already prescribed. The DOJ affirmed the resolution of the assistant city prosecutor and held in favor of the respondent. Subsequently, the DOJ, this time through the undersecretary, ruled in favor of the petitioner/complainant, declaring that the offense had not prescribed and that the filing of the complaint with the prosecutor's office interrupted the running of the prescriptive period. Thus, the office of the city prosecutor of Quezon City was directed to file 3 separate informations against the respondent for violation of BP 22. The informations were filed. Later, the DOJ, presumably acting on a motion for reconsideration filed by the respondent, ruled that the subject offense had already prescribed and ordered the withdrawal of the 3 informations for violation of BP 22. In justifying its sudden turnabout, the DOJ explained that Act No. 3326 applies to violations of special acts that do not provide for a prescriptive period for the offenses thereunder. Since BP 22, as a special act, does not provide for the prescription of the offense it defines and punishes, Act No. 3326 applies to it, and not Article 90 of the revised Penal Code, which governs the prescription of offenses penalized thereunder. The DOJ also cited the case of Zaldivia v. Reyes, Jr., wherein the Supreme Court ruled that the proceedings referred to in Act No. 3326, as amended, are judicial proceedings, and not the one before the prosecutor's office. Aggrieved, the petitioner then filed a petition for certiorari before the Court of Appeals assailing the latest resolution of the DOJ, but the petition was dismissed by the Court of Appeals on technical grounds. In the Supreme Court, the DOJ reiterated its earlier argument that the filing of a complaint with the office of the city prosecutor of Quezon City did not interrupt the running of the prescriptive period for violation of BP 22. It argued that under BP 22, a special law which does not provide for its own prescriptive period, offenses prescribe in 4 years in accordance with Act No. 3326. The respondent also claimed that the offense of violation of BP 22 has already prescribed per Act No. 3326. On the other hand, the petitioner assailed the DOJ's reliance on Zaldivia v. Reyes, a case involving the violation of a municipal ordinance, in declaring that the prescriptive period is told only upon filing of the information in court. According to petitioner, what is applicable in this case is Inco v. Sandiganbayan, wherein the Supreme Court ruled that the filing of the complaint with the fiscal's office for preliminary investigation suspends the running of the prescriptive period. Petitioner also noted that the Inco case similarly involved the violation of a special law, Republic Act No. 3019, otherwise known as the Anti-Graft and Corrupt Practices Act. In resolving the issue, the court declared, "We agree that Act No. 3326 applies to offenses under BP 22. An offense under BP 22 merits the penalty of imprisonment of not less than 30 days but not more than 1 year, or by a fine, Hence, under Act No. 3326, a violation of BP 22 prescribes in 4 years from the commission of the offence or, if the same be not known at the time, from the discovery thereof. Nevertheless, we cannot uphold the position that only the filing of a case in court can toll the running of the prescriptive period. The court also explained that when Act No. 3326 was passed, preliminary investigation could be conducted by justices of the peace. Thus, the phraseology in the law, institution of judicial proceedings for its investigation and punishment. We rule and so hold that the offence has not yet prescribed. Petitioner's filing of his complaint affidavit before the office of the city prosecutor signified the commencement of the proceedings for the prosecution of the accused and thus, effectively interrupted the prescriptive period for the offences they had been charged under for. A significant pronouncement which confirms the rule that the filing of a complaint for purposes of preliminary investigation interrupts the period of prescription of criminal responsibility, was made by the court in the case of SEC v. Interport Resources Corporation. This case relates to a petition for review on certiorari under Rule 45 of the Rules of Court, assailing the decision of the Court of Appeals enjoining the Securities and Exchange Commission, SEC, from taking cognizance of or initiating any action against the respondent corporation, Interport Resources Corporation, IRC, and members of its board of directors with respect to Sections 8, 30, and 36 of the Revised Securities Act. Respondents have taken the position that this case is moot and academic, since any criminal complaint that may be filed against them resulting from the SEC's investigation of this case has already prescribed. They point out that the prescription period applicable to offences punished under special laws, such as violations of the Revised Securities Act, is 12 years under Section 1 of Act No. 3326, as amended by Act No. 3585 and Act No. 3763, entitled An Act to Establish Periods of Prescription for Violations Penalized by Special Acts and Municipal Ordinances and to provide when prescription shall begin to run. Since the offence was committed in 1994, they reasoned that prescription set in as early as 2006 and rendered this case moot. Ruling against the respondent, the court held it to be an established doctrine that a preliminary investigation interrupts the prescription period. A preliminary investigation is essentially a determination whether an offence has been committed, and whether there is probable cause for the accused to have committed an offence. Under Section 45 of the Revised Securities Act, which is entitled Investigations, Injunctions, and Prosecution of Offences, the Securities and Exchange Commission, SEC, has the authority to make such investigations as it deems necessary to determine whether any person has violated or is about to violate any provision of the law. After a finding that a person has violated the Revised Securities Act, the SEC may refer the case to the DOJ for preliminary investigation and prosecution. The court added that while the SEC investigation serves the same purpose and entails substantially similar duties as the preliminary investigation conducted by the DOJ, this process cannot simply be disregarded. The court further ruled that a criminal charge for violation of the Securities Regulation Code is a specialized dispute. Hence, it must first be referred to an administrative agency of special competence, i.e., the SEC. Under the doctrine of primary jurisdiction, courts will not determine a controversy involving a question within the jurisdiction of the administrative tribunal, where the question demands the exercise of sound administrative discretion requiring the specialized knowledge and expertise of said administrative tribunal to determine technical and intricate matters of fact. The court observed that the Securities Regulation Code is a special law. Its enforcement is particularly vested in the section. Hence, all complaints for any violation of the code and its implementing rules and regulations should be filed with the section where the complaint is criminal in nature. The SEC shall endorse the complaint to the DOJ for preliminary investigation and prosecution as provided in Section 53. Indubitably, declared succinctly by the court, the prescription period is interrupted by commencing the proceedings for the prosecution of the accused. In criminal cases, this is accomplished by initiating the preliminary investigation. The prosecution of offences punishable under the Revised Securities Act and the Securities Regulations Code is initiated by the filing of a complaint with the SEC or by an investigation conducted by the SEC motu proprio. Only after a finding of probable cause is made by the SEC can the DOJ instigate a preliminary investigation. Thus, the investigation that was commenced by the SEC, soon after it discovered the questionable acts of the respondents, effectively interrupted the prescription period. Given the nature and purpose of the investigation conducted by the SEC, which is equivalent to the preliminary investigation conducted by the DOJ in criminal cases, such investigation would surely interrupt the prescription period. Note that the cases of Sanrio, Panagatan, and SEC, cited above all involved violations of special laws. Uniformly in these cases, the court had declared that the filing of the affidavit of complaint for preliminary investigation interrupted the running of the prescriptive period.
Part 2. Prosecution of the criminal action.
Who must prosecute the criminal action? Who controls the prosecution? Bar 1990, 2000. 1. A criminal action is prosecuted under the direction and control of the public prosecutor. This is the general rule, and this applies to a criminal action commenced either by a complaint or an information. Section 5, Rule 110. All criminal actions covered by a complaint or information shall be prosecuted under the direct supervision and control of the public prosecutor. Recars v. Court of Appeals. Even if there is a private prosecutor, the criminal action is still prosecuted under the direction and control of the public prosecutor. 2. The rationale for the rule that all criminal actions shall be prosecuted under the direction and control of a public prosecutor is that since a criminal offense is an outrage against the sovereignty of the state, it necessarily follows that a representative of the state shall direct and control the prosecution thereof. Chua v. Padillo. The mandate that all criminal actions, either commenced by a complaint or information, shall be prosecuted under the direction and control of a public prosecutor, is founded on the theory that a crime is a breach of the security and peace of the people at large, an outrage against the very sovereignty of the state. Baviera v. Paglina 1. Appearance of a private prosecutor. 1. The appointment of a private prosecutor is done by the offended party and is the mode by which the latter intervenes in the prosecution of the offense. This intervention is, however, only allowed where the civil action for the recovery of the civil liability is instituted in the criminal action pursuant to Rule 111, Section 16, Rule 110, Rules of Court. 2. Hence, the offended party may not intervene in the prosecution of the offense through a private prosecutor if the offended party, a. waives the civil action, b. reserves the right to institute it separately, or, c. institutes the civil action prior to the criminal action. Effect of the filing of an independent civil action on the right of the offended party to intervene in the prosecution of the offense. 1. The institution of an independent civil action does not deprive the offended party of the right to intervene in the civil action through a private prosecutor. 2. Under Section 1 of Rule 111 of the 2000 Rules of Criminal Procedure, when a criminal action is instituted, the civil action for the recovery of civil liability arising from the offense charged shall be deemed instituted with the criminal action unless the offended party waives the civil action, reserves the right to institute it separately, or institutes the civil action prior to the criminal action. 3. Note, however, that pursuant to said provision, only the civil liability of the accused arising from the offense charged is deemed impliedly instituted in a criminal action, unless the offended party waives the civil action, reserves the right to institute it separately, or institutes it prior to the criminal action. Those not arising from the offense charged, like the independent civil actions referred to in Articles 32, 33, 34, and 2176 of the Civil Code, are not deemed instituted with the criminal action. These actions, according to Section 3 of Rule 111 of the Rules of Court, shall proceed independently of the criminal action. Thus, the 2000 Rules of Criminal Procedure deleted the requirement of reserving independent civil actions and allowed these to proceed separately from criminal actions because they are separate, distinct, and independent of any criminal prosecution, even if based on the same act which also gave rise to the criminal action. For thus, it was ruled that as one of the direct consequences of the independent character of actions brought under Articles 32, 33, 34, and 2176 of the Civil Code, even if a civil action is filed separately, the ex delicto civil liability in the criminal prosecution remains, and the offended party may, subject to the control of the prosecutor, still intervene in the criminal action, in order to protect the remaining civil interest therein. Philippine Rabbit Bus Lines vs. People. Consequences of the rule that a criminal action is prosecuted under the direction and control of the public prosecutor. 1. The public prosecutor, in the exercise of his functions, has the power and discretion to a. determine whether a prima facie case exists, b. decide which of the conflicting testimonies should be believed free from the interference or control of the offended party, and c. subject only to the right against self-incrimination, determine which witnesses to present in court. The public prosecutor may turn over the actual prosecution of the criminal case to the private prosecutor, in the exercise of his discretion, but he may at any time take over the actual conduct of the trial. The executive department of the government is accountable for the prosecution of crimes. The right to prosecute vests the prosecutor with a wide range of discretion, the discretion of whether, what and whom to charge, the exercise of which depends on factors which are best appreciated by prosecutors, Gonzalez v. Hong Kong and Shanghai Banking Corporation. 2. The power to prosecute includes the initial discretion to determine who should be utilized by the government as a state witness, People v. Fajardo. 3. The prosecution is also entitled to conduct its own case and to decide what witnesses to call to support its charges. The non-presentation of a witness by the prosecution cannot be construed as suppression of evidence where the testimony is merely corroborative, Ritualo v. People. 4. Not even the Supreme Court can order the prosecution of a person against whom the prosecutor does not find sufficient evidence to support at least a prima facie case. The only possible exception to the rule is where there is an unmistakable showing of grave abuse of discretion on the part of the prosecutor, Chua v. Padillo. 5. In one case, 3 informations were filed against the petitioner before the Regional Trial Court of Pasig City. 1 information pertains to allegations that petitioner employed manipulative devices in the purchase of Best World Resources Corporation, BW, shares. The other informations involve the alleged failure of petitioner to file with the Securities and Exchange Commission, SEC, a sworn statement of his beneficial ownership of BW shares. The petitioner was arraigned and pleaded not guilty to the charges. Subsequently, the trial court ruled that the delays which attended the proceedings of one of the petitioner's cases were vexatious, capricious, and oppressive, resulting in violation of the petitioner's right to speedy trial and hence, ordered its dismissal. The dismissal was later on reversed by the Court of Appeals and reinstated the case previously dismissed. Petitioner moved for a reconsideration of the decision of the Court of Appeals and filed a motion for inhibition of the justices who decided the case, but both motions were denied. The petitioner hence filed a petition for review on certiorari, raising among others the issue that the certificate of non-forum shopping attached to the people's petition for certiorari before the Court of Appeals should have been signed by the chairman of the SEC as complainant in the cases instead of acting DOJ Secretary Mercaditas and Gutierrez. The court found the petitioner's argument futile, holding that the Court of Appeals was correct in sustaining the authority of acting DOJ Secretary Mercaditas Gutierrez to sign the certification. The court went on to say that it must be stressed that the certification against forum shopping is required to be executed by the plaintiff. Although the complaint affidavit was signed by the Prosecution and Enforcement Department of the SEC, the petition before the Court of Appeals originated from criminal case number 119,830, where the plaintiff or the party instituting the case was the people of the Philippines. Section 2, Rule 110 of the Rules of Court leaves no room for doubt and establishes that criminal cases are prosecuted in the name of the people of the Philippines, the offended party in criminal cases. Moreover, pursuant to Section 3, Paragraph 2, of the Revised Administrative Code, the DOJ is the executive arm of the government mandated to investigate the commission of crimes, prosecute offenders, and administer the probation and correction system. It is the DOJ, through its prosecutors, which is authorized to prosecute criminal cases on behalf of the people of the Philippines. Prosecutors control and direct the prosecution of criminal offenses, including the conduct of preliminary investigation, subject to review by the Secretary of Justice. Since it is the DOJ which is the government agency tasked to prosecute criminal cases before the trial court, the DOJ is best suited to attest whether a similar or related case has been filed or is pending in another court or tribunal. Acting DOJ Secretary Mercaditas and Gutierrez, being the head of the DOJ, therefore, had the authority to sign the certificate of non-forum shopping for the criminal case which was filed on behalf of the people of the Philippines, Tan vs. People. 6. In a case, the accused argues that he can no longer be charged because he was left alone after either the death or acquittal or the failure to charge his co-conspirators. The accused likewise argues that his prosecution, to the exclusion of others, constitutes unfair discrimination and violates his constitutional right to equal protection of the law. He says that the dismissal of the case against his co-accused was not appealed by the prosecution and some who should be accused were not charged. The court considered the argument erroneous. A conspiracy is in its nature a joint offense. One person cannot conspire alone. The crime depends upon the joint act or intent of 2 or more persons. Yet, it does not follow that one person cannot be convicted of conspiracy. As long as the acquittal or death of a co-conspirator does not remove the basis of a charge of conspiracy, one defendant may be found guilty of the offense. The court also held that the accused was not unfairly discriminated against and his constitutional right to equal protection violated. The court explained that the manner in which the prosecution of the case is handled is within the sound discretion of the prosecutor, and the non-inclusion of other guilty persons is irrelevant to the case against the accused. A discriminatory purpose is never presumed. The facts show that it was not solely the respondent who was charged, but also 5 others. Further, the fact that the dismissal of the DOS against his co-accused was not appealed is not sufficient to cry discrimination. This is likewise true for the non-inclusion of the 2 persons. Mere speculation, unsupported by convincing evidence, cannot establish discrimination on the part of the prosecution and the denial to respondent of the equal protection of the laws, People v. Dumlau. 7. Another case lucidly illustrates the consequences of the rule that the prosecution of a crime is under the direction and control of the public prosecutor. Thus, in the case of Pinot v. Aco, the trial judge allowed the defense to present evidence consisting of the testimony of 2 witnesses, even in the absence of the prosecutor charged with prosecuting the case. The prosecutor at the time was undergoing medical treatment at the Philippine Heart Center in Quezon City. Maintaining that the proceedings conducted in his absence were void, the prosecutor, on the subsequent hearings of the case, refused to cross-examine the 2 defense witnesses, despite being ordered by the judge. After manifesting to the court the reason for his absence, a reason earlier relayed to the court on the day of the hearing in question, he reiterated his position that the act of the judge of allowing the defense to present evidence in his absence was erroneous and highly irregular. He thus prayed that he should not be coerced to cross-examine those 2 defense witnesses and that their testimonies be stricken off the record. The judge, nevertheless, considered the prosecution to have waived its right to cross-examine the 2 defense witnesses. An administrative complaint was then lodged by the prosecutor against the judge for gross ignorance of the law, grave abuse of authority and serious misconduct. On evaluation of the case, the Office of the Court Administrator, OCA, citing Section 5, Rule 110 of the Revised Rule on Criminal Procedure, found respondent judge to have breached said rule and accordingly recommended that he be reprimanded, with a warning that a repetition of the same 05 similar act shall be dealt with more severely. Adopting the findings of the Office of the Court Administrator, the court ruled that a violation of criminal laws is an affront to the people of the Philippines as a whole and not merely to the person directly prejudiced, he being merely the complaining witness. It is on this account, held the court, that the presence of a public prosecutor in the trial of criminal cases is necessary to protect vital state interests, foremost of which is its interest to vindicate the rule of law, the bedrock of peace of the people. The act of allowing the presentation of the defense witnesses in the absence of complainant public prosecutor or a private prosecutor designated for the purpose is a clear transgression of the rules which could not be rectified by subsequently giving the prosecution a chance to cross-examine the witnesses. Added the court. Respondent's intention to uphold the right of the accused to a speedy disposition of the case, no matter how noble it may be, cannot justify a breach of the rules. If the accused is entitled to due process, so is the state. Prosecution of a criminal action in the municipal trial court or municipal circuit trial court. A criminal action in a municipal trial court or in a municipal circuit trial court shall also be prosecuted under the direction and control of the prosecutor, Section 5, Rule 110, Rules of Court. However, when the prosecutor assigned is not available, the action may be prosecuted by a. the offended party, b. any peace officer, c. or public officer charged with the enforcement of the law violated. Prosecution for violation of special laws. Where the offense is a violation of a special law, the same shall be prosecuted pursuant to the provisions of said law, Section 5, Rule 110, Rules of Court.
Part 3. Intervention of the offended party in the prosecution of the criminal action.
Intervention of the offended party. A fundamental principle in criminal law is the rule that every person criminally liable for a felony is also civilly liable, Article 100, Revised Penal Code. Thus, generally, a person convicted of a crime is both criminally and civilly liable. 2. The civil liability for a crime includes restitution, reparation of the damage caused and indemnification for consequential damages, Article 104, Revised Penal Code. Except when the civil liability is extinguished, the offender shall be obliged to satisfy the civil liability resulting from the crime committed by him, even if he has already served his sentence consisting of deprivation of liberty or other rights, or has not been required to serve the same by reason of amnesty, pardon, commutation of sentence or any other reasons. 3. It is because of the existence of a civil liability involved in a crime, that the offended party is allowed to intervene in the prosecution of the offense. Thus, Section 16 of Rule 110 provides that where the civil action for recovery of civil liability is instituted in the criminal action pursuant to Rule 111, the offended party may intervene by counsel in the prosecution of the offense. 4. By virtue of Section 16 of Rule 110 in relation to Section 1 of Rule 111, For the offended party to acquire the right to intervene in the prosecution of the offense, it is necessary that the civil action for the recovery of the civil liability be instituted with the criminal action. If the civil liability has been waived, or the civil action to recover the civil liability has been reserved or has been instituted prior to the criminal action, there is no civil liability which would supply a basis for the intervention of the offended party through his counsel or private prosecutor. The presence of a private prosecutor in THP criminal action may be objected to by the prosecution. 5. There are, however, cases where the criminal action also gives rise to an independent civil action, as in crimes involving physical injuries, fraud, or defamation, or when the act constituting a crime also constitutes a quasi-delict. These situations give rise to distinct civil liabilities, to wit, the one arising from the offense charged under Article 100 of the Revised Penal Code, and the civil liabilities arising from quasi-delicts or independent civil actions. Worthy of note is the principle that the latter sources of civil liabilities do not arise from the offense charged. By virtue of its independent character as a distinct source of civil liability, the filing of a suit based on a quasi-delict theory during the pendency of the criminal proceeding should not prevent the intervention by the offended party in the prosecution of the offense, because there still exists a civil liability under the Revised Penal Code, i.e., the civil liability arising from the offense charged, which would be the basis for the intervention. This is because the civil liability arising from a quasi-delict is entirely separate and distinct from the civil liability arising from negligence under the Penal Code, Article 2177, Civil Code of the Philippines. Also, in the case of independent civil actions, they may proceed independently of the criminal action, Section 3, Rule 111, Rules of Court. 6. It needs to be emphasized that the civil liabilities arising from independent civil actions and a quasi-delict do not arise from the felony or crime, and have distinct sources from the law or the civil code. They are not, hence, covered by the provision of the Revised Penal Code declaring that persons liable for a felony are also civilly liable. Such civil actions may proceed independently of the criminal proceedings and regardless of the result of the latter, Article 31, Civil Code of the Philippines. When a private prosecutor may prosecute a case even in the absence of the public prosecutor. 1. A private prosecutor may prosecute the criminal action up to the end of the trial even in the absence of the public prosecutor if he is authorized to do so in writing. This written authorization shall be given by either the Chief of the Prosecution Office or the Regional State Prosecutor. The written authorization, in order to be given effect, must, however, be approved by the court, Section 5, Rule 110, Rules of Court. 2. The written authorization to the private prosecutor shall be given because of either of the following reasons: a. The public prosecutor has a heavy work schedule, or b. There is a lack of public prosecutors, Section 5, Rule 110, Rules of Court. Extent of the authority given to the private prosecutor when duly authorized to prosecute the action. Once so authorized to prosecute the criminal action, the private prosecutor shall continue to prosecute the case up to the end of the trial even in the absence of a public prosecutor, unless the authority is revoked or otherwise withdrawn, Section 5, Rule 110, Rules of Court.
Part 4. Prosecution of Private Crimes.
Prosecution of Adultery and Concubinage. 1. The crimes of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended spouse. The rule is clear: the prosecutor cannot prosecute the case where no complaint is filed by the offended spouse. The same rule also provides that the action cannot be instituted against one party alone. It must be instituted against both guilty parties, unless one of them is no longer alive. 2. The offense of adultery and concubinage may not be instituted if it is shown that the offended party has consented to the offense or has pardoned the offenders, Section 5, Rule 110, Rules of Court. Since the rule does not distinguish, the consent or pardon may be either expressed or implied. Prosecution of seduction, abduction, and acts of lasciviousness. 1. The offenses of seduction, abduction, and acts of lasciviousness shall not be prosecuted except upon a complaint filed by the offended party or her parents, grandparents, or guardian, nor, in any case, if the offender has been expressly pardoned by any of them. Note that the pardon must be expressly made. It is clear that an implied pardon is not contemplated under this provision. However, if the offended party dies or becomes incapacitated before she can file the complaint, and she has no known parents, grandparents, or guardian, the state shall initiate the criminal action in her behalf. In the order of those who may file the complaint, the state is the last and may only do so in the absence of the persons mentioned in Section 5 of Rule 110. 2. Also, under Section 5 of Rule 110, the offended party, even if a minor, has the right to initiate the prosecution of the offense, independently of her parents, grandparents, or guardian except if she is incompetent or incapable of doing so. Where the minor fails to initiate the prosecution of the offense, the complaint may be filed by the minor's parents, grandparents, or guardian. Section 5, Rule 110, Rules of Court.
Subscribe for more audiobooks like this.
Effect of RA 7610, Special Protection of Children Against Child Abuse, Exploitation, and Discrimination Act. Under Section 27 of RA 7610, complaints on cases of unlawful acts mentioned in the law committed against children may be filed by the following: A. Offended party. B. Parents or guardians. C. Ascendant or collateral relative within the third degree of consanguinity. D. Officer, social worker, or representative of a licensed child-caring institution. E. Officer or social worker of the Department of Social Welfare and Development. F. Barangay chairman, or G. At least 3 concerned, responsible citizens where the violation occurred. Prosecution of defamation. 1. The defamation under this rule consists in the imputation of the offenses of adultery, concubinage, seduction, abduction, and acts of lasciviousness, Section 5, Rule 110, Rules of Court. 2. The criminal action for defamation under the rule shall be brought at the instance of and upon the complaint filed by the offended party, Section 5, Rule 110, Rules of Court. This rule clearly provides that only the offended party can initiate the criminal action.
Part 5. The complaint and information.
Meaning of complaint. 1. A complaint is a sworn written statement charging a person with an offense, subscribed by the offended party, any peace officer, or other public officer, charged with the enforcement of the law violated, Section 3, Rule 110, Rules of Court. 2. A complaint is not a mere statement. It is a statement charging a person with an offense. As a statement it must be sworn and written. Be it noted too that the complaint is subscribed only by any of the persons specified in the rule, namely, the offended party, any peace officer, or other public officer charged with the enforcement of the law violated. In whose name and against whom filed. 1. The complaint is not filed in the name of a private person, natural or juridical. It is filed in the name of the people of the Philippines and is filed against all persons who appear to be responsible for the offense involved, Section 2, Rule 110, Rules of Court. 2. Private offended parties have limited roles in criminal cases. They are only witnesses for the prosecution. Thus, a private offended party may not appeal the dismissal of a criminal case or the acquittal of an accused because the aggrieved party is the people of the Philippines. However, the offended party may appeal the civil aspect of the case and may, thus, file a special civil action for certiorari questioning the decision/action of the court on jurisdictional grounds. In so doing, the private offended party cannot bring the action in the name of the people of the Philippines, but must prosecute the same in his own personal capacity. The dismissal made by the RDC of the criminal case can only be appealed by the OSG. The private offended party has no legal personality to do so. Here, the Supreme Court applied the general rule under Section 35, 1, Chapter 12 of the Administrative Code of 1987, which provided that only the OSG can bring and/or defend actions on behalf of the Republic or represent the people or the state in criminal proceedings pending in the Supreme Court and the CA, Ong vs. Genio. Note, any appeal is subject to the rule against double jeopardy, Section 1, Rule 122. Meaning of information, bar 1994-1995-1996. 1. An information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court, Section 4, Rule 110. 2. While an information is an accusation in writing, it is not required to be sworn, unlike a complaint. Only a public officer described by the rules of court as a prosecutor is authorized to subscribe to the information, Section 4, Rule 110, Rules of Court. 3. Like a complaint, an information is filed in the name of the people of the Philippines against all persons who appear to be responsible for the offense involved, Section 2, Rule 110, Rules of Court. Distinctions between a complaint and an information, bar 1999. 1. A complaint must be sworn, hence, under oath. By the clear terms of Section 3 of Rule 110, it is a sworn written statement. An information requires no oath. Section 4 of Rule 110 merely requires that it be an accusation in writing. This is because the prosecutor filing the information is acting under the oath of his office. 2. A complaint or information is subscribed by a. the offended party, b. any peace officer, c. or other public officer charged with the enforcement of the law violated. Section 3, Rule 110, Rules of Court. On the other hand, an information is subscribed by the prosecutor. Section 4, Rule 110, Rules of Court. Infirmity of signature in the information. It is a valid information signed by a competent officer which, among other requisites, confers jurisdiction on the court over the person of the accused and the subject matter of the accusation. In consonance with this view, an infirmity in the information, such as lack of authority of the officer signing it, cannot be cured by silence, acquiescence, or even by express consent. Cudia v. Court of Appeals. Sufficiency of the complaint or information, Bar 1994, 2001. 1. A complaint or an information is deemed sufficient if it contains the following. A. The name of the accused. If the offense is committed by more than one person, all of them shall be included in the complaint or information. The designation of the offense given by statute. The acts or omissions complained of as constituting the offense. The name of the offended party. The approximate date of the commission of the offense, and the place where the offense was committed. Section 6, Rule 110. 2. A complaint or information is sufficient if it states the name of the accused, the designation of the offense by the statute, the acts or omissions complained of as constituting the offense, the name of the offended party, the approximate date of the commission of the offense and the place where the offense was committed. Malto v. People. Test for sufficiency of the complaint or information. 1. The test is whether the crime is described in intelligible terms with such particularity as to apprise the accused, with reasonable certainty, of the offense charged. Lazart, Jr. v. Sandigan-Bayan, because the purpose of the requirement for the information's validity and sufficiency is to enable the accused to suitably prepare for his defense, since he is presumed to have no independent knowledge of the facts that constitute the offense. People v. Cinco. Questioning the insufficiency of the complaint or information. The sufficiency of an information may be assailed, but the right to question the sufficiency of the same is not absolute. An accused is deemed to have waived this right if he fails to object upon his arraignment or during trial. In either case, evidence presented during trial can cure the defect in the information. An accused is deemed to have waived his right to assail the sufficiency of the information when he voluntarily entered a plea when arraigned and participated in the trial. Frias v. People. Objections as to form. Objections relating to the form of the complaint or information cannot be made for the first time on appeal. The accused appellant should have moved before arraignment either for a bill of particulars or for the quashal of the information. Having failed to pursue either remedy, he is deemed to have waived his objections to any formal defect in the information. The People of the Philippines v. Romar Teodoro y Vallejo. Date of the commission of the offense. 1. Section 11 of the same rule also provides that it is not necessary to state in the complaint or information the precise date the offense was committed except when the date of commission is a material element of the offense. The offense may thus be alleged to have been committed on a date as near as possible to the actual date of its commission. At the minimum, an indictment must contain all the essential elements of the offense charged to enable the accused to properly meet the charge and duly prepare for his defense. Section 11, Rule 110, Rules of Court, People v. Canaries. In rape cases, for instance, the failure to specify the exact dates or times when the rape occurred does not ipso facto make the information defective on its face. The reason is obvious. The date or time of the commission of rape is not a material ingredient of the said crime because the gravamen of rape is carnal knowledge of a woman through force and intimidation. The precise time when the rape took place has no substantial bearing on its commission. As such, the date or time need not be stated with absolute accuracy. People v. Cinco. Determination of the nature and character of the crime. 1. The character of the crime is determined neither by the caption or preamble of the information nor by the specification of the provision of law alleged to have been violated, they being conclusions of law, but by the recital of the ultimate facts and circumstances in the information. Consequently, even if the designation of the crime in the information was defective, what is controlling is the allegation of the facts in the information that comprises a crime and adequately describes the nature and cause of the accusation against the accused. People v. Anguac. 2. It is axiomatic that the nature and character of the crime charged are determined not by the designation of the specific crime, but by the facts alleged in the information. Controlling in an information should not be the title of the complaint or the designation of the offense charged or the particular law or part thereof allegedly violated, these being, by and large, mere conclusions of law made by the prosecutor, but the description of the crime charged and the particular facts therein recited. People v. Quamegan. How to state the name of the accused. 1. Section 7 of Rule 110 establishes the following rules in designating the name of the accused. A. The complaint or information must state the name and surname of the accused or any appellation or nickname by which he has been or is known. B. If his name cannot be ascertained, he must be described under a fictitious name. A description of the accused under a fictitious name must be accompanied by a statement that his true name is unknown. C. If later his true name is disclosed by him or becomes known in some other manner, his true name shall be inserted in the complaint or information and in the records of the case. 2. A mistake in the name of the accused is not equivalent, and does not necessarily amount to, a mistake in the identity of the accused, especially when sufficient evidence is adduced to show that the accused is pointed to as one of the perpetrators of the crime. People v. Ammodia. However, the identity of the accused must be proven. People v. Tumaming. How to state the name of the offended party who is a natural person. The complaint or information must state the name and surname of the offended party or any appellation or nickname by which such person has been or is known. However, if there is no better way of identifying him, he must be described under a fictitious name. If later on, the true name of the offended party is disclosed or ascertained, the court must cause such true name to be inserted. Section 12, Rule 110. How to state the name of the offended party which is a juridical person. If the offended party is a juridical person, it is sufficient to state its name or any name or designation by which it is known or by which it may be identified, without need of averring that it is a juridical person or that it is organized in accordance with law. Section 12c, Rule 110. Rule if the name of the offended party is unknown in offenses against property. In offenses against property, if the name of the offended party is unknown, the property must be described with such particularity as to properly identify the offense charged. Section 12a, Rule 110. In Sesson v. People, the court ruled that in case of offenses against property, the designation of the name of the offended party is not absolutely indispensable for as long as the criminal act charged in the complaint or information can be properly identified. Designation of the offense. 1. It is settled that it is the allegations in the information that determine the nature of the offense, not the technical name given by the public prosecutor in the preamble of the information. From a legal point of view, and in a very real sense, it is of no concern to the accused what is the technical name of the crime of which he stands charged. It in no way aids him in a defense on the merits. That to which his attention should be directed, and in which he, above all things else, should be most interested, are the facts alleged. The real question is not did he commit a crime given in the law some technical and specific name, but did he perform the acts alleged in the body of the information in the manner therein set forth. Trudeau v. People. The specific acts of the accused do not have to be described in detail in the information, as it is enough that the offense be described with sufficient particularity to make sure the accused fully understands what he is being charged with. The particularity must be such that a person of ordinary intelligence immediately knows what the charge is. Moreover, reasonable certainty in the statement of the crime suffices. Guy v. People. 2. In designating the offense, the following rules must be observed. A. The designation of the offense requires, as a rule, that the name given to the offense by statute must be stated in the complaint or information. If the statute gives no designation to the offense, then reference must instead be made to the section or one subsection punishing it. B. To be included in the complete designation of the offense is an averment of the acts or omissions constituting the offense. Section 8, Rule 110. C. The complaint or information must specify the qualifying and aggravating circumstances of the offense. Section 8, Rule 110. Effect of failure to designate the offense by the statute or failure to mention the provision violated. 1. The failure to designate the offense by the statute or to mention the specific provision penalizing the act or an erroneous specification of the law violated does not vitiate the information if the facts alleged clearly recite the facts constituting the crime charged. Malto v. People. There is no law which requires that in order that an accused may be convicted, the specific provision which penalizes the act charged be mentioned in the information. Lasaio v. People. 2. In Lasaio v. People, the information accuses the accused of the crime of homicide but does not categorically state that he is being charged with homicide as defined and penalized under Article 249 of the Revised Penal Code. The accused argues that the specification in the information of the law violated is necessary to enable him to adequately prepare for his defense, and to convict him under such defective information would allegedly violate his constitutional and statutory right to be informed of the nature and cause of accusation against him. The court ruled that the fact that the information does not specifically mention Article 249 of the Revised Penal Code as the law which defines and penalizes homicide, does not make the information defective. There is nothing in the rules of court which specifically requires that the information must state the particular law under which the accused is charged in order for it to be considered sufficient and valid. Although the information does not specifically mention Article 249 of the Revised Penal Code, it nonetheless narrates that the accused stabbed the victim with a blade weapon during the incident which caused the latter's death. The allegations, according to the court, unmistakably refer to homicide, which is the unlawful killing of any person other than murder, homicide, or infanticide. The court likewise held in the same case that the sufficiency of an information is not negated by an incomplete or defective designation of the crime in the caption or other parts of the information, but by the narration of facts and circumstances which adequately depicts a crime and sufficiently appraisers the accused of the nature and cause of the accusation against him. The court in the case asserted that the character of the crime is determined neither by the caption or preamble of the information nor by the specification of the provision of law alleged to have been violated, they being conclusions of law, but by the recital of the ultimate facts and circumstances in the information. Effect of failure to specify the correct crime. The failure to specify the correct crime committed will not bar conviction of an accused. The character of the crime is not determined by the caption or preamble of the information or by the specification of the provision of law alleged to have been violated. The crime committed is determined by the recital of the ultimate facts and circumstances in the complaint or information.
Subscribe for more audiobooks like this.
Statement of the Qualifying and Aggravating Circumstances, Bar 2001. 1. Every information must state the qualifying and the aggravating circumstances attending the commission of the crime for them to be considered in the imposition of the penalty. People v. Tompkins. The rationale for the requirement was elucidated in a much earlier case. In People v. Mendoza, the accused was found guilty by the trial court of 2 counts of rape, each qualified by the use of a deadly weapon. The informations, however, did not allege that the rapes were committed with the use of a deadly weapon. The court was emphatic when it declared that the accused cannot be convicted of rape qualified by the use of a deadly weapon and be made to suffer a higher penalty since that circumstance was not alleged in the information. Not having been alleged and having been charged with simple rape only, the accused cannot be convicted of qualified rape. He cannot be held liable for an offense graver than that for which he was indicted. It would be a denial of the right of the accused to be informed of the charges against him, and consequently, a denial of due process, if he is charged with simple rape, on which he was arraigned, and be convicted of qualified rape punishable by death. 2. In one information for arson, there was no allegation that the house intentionally burned by petitioners and their cohorts was inhabited. Rather, the information merely recited that accused, conspiring, confederating and helping one another, with intent to cause damage, did then and there willfully, unlawfully, feloniously, and maliciously set on fire the NEPA roof of the house of the offended party to the latter's damage and prejudice. Under the 2000 Rules of Criminal Procedure, the information or complaint must state the designation of the offense given by the statute and specify its qualifying and generic aggravating circumstances. Otherwise stated, the accused will not be convicted of the offense proved during the trial if it was not properly alleged in the information. Hence, he can only be liable for simple arson and not arson of an inhabited dwelling, which carries a higher penalty. Buebos v. People. Prior to the effectivity of the revised rules of criminal procedure, courts generally awarded exemplary damages in criminal cases when an aggravating circumstance, whether ordinary or qualifying, had been proven to have attended the commission of the crime, even if the same was not alleged in the information. However, with the promulgation of the revised rules, courts could no longer consider the aggravating circumstances not alleged and proven in the determination of the penalty and in the award of damages. Thus, even if an aggravating circumstance had been proven, but was not alleged, courts will not award exemplary damages. Also, even if the guilt of the accused was proven beyond reasonable doubt, the accused cannot be convicted of qualified rape but only with simple rape because the special qualifying circumstances of minority and relationship were not sufficiently alleged in the information. People v. Delice. 3. The qualifying circumstances need not be preceded by descriptive words such as qualifying or qualified by to properly qualify an offense. It is not the use of the words qualifying or qualified by that raises a crime to a higher category, but the specific allegation of an attendant circumstance which adds the essential element raising the crime to a higher category. People v. Rosas. 4. In one case brought to the Supreme Court, both the accused contend that the information did not contain any allegation of conspiracy, either by the use of the words conspire or its derivatives and synonyms, or by allegations of basic facts constituting conspiracy that will make them liable for the acts of their co-accused. The court considered the contention untenable. It is true as it is settled, declared the court, that conspiracy must be alleged, not merely inferred in the information. The court, however, found that while a perusal of the information readily shows that the words conspiracy, conspired or in conspiracy with do not appear in the information, this, however, does not necessarily mean that the absence of these words would signify that conspiracy was not alleged in the information. After carefully reading the information, the court concluded that indeed conspiracy was properly alleged in the information. The accusatory portion reads in part, all the above-named accused, with evident intent to defraud the government of legitimate taxes accruing to it from imported articles, did then and there, willfully, unlawfully, and knowingly participate in and facilitate the transportation, concealment, and possession of dutiable electronic equipment and accessories with a domestic market value of 20 million pesos contained in container van, but which were declared in formal entry and revenue declaration as assorted men's and ladies' accessories. The court ruled that we find the phrase participate in and facilitate to be a clear and definite allegation of conspiracy sufficient for those being accused to competently enter a plea and to make a proper defense. Both accused were charged because they assisted in and facilitated the release of the subject cargo without the payment of the proper duties and taxes due the government by omitting certain acts in the light of glaring discrepancies and suspicious entries present in the documents involved in the subject importation, Francisco v. People. 5. A similar pronouncement was made by the court in a fairly recent case. In People v. Ubifaya, the court declared that the twin circumstances of minority and relationship under Article 335 of the Revised Penal Code, as amended by RA No. 7659, are in the nature of qualifying circumstances because they alter the nature of the crime of rape and increase the penalty. As special qualifying circumstances, they must be specifically pleaded or alleged with certainty in the information. If the offender is merely a relation, not a parent, ascendant, step-parent, guardian, or common law spouse of the mother of the victim, the specific relationship must be alleged in the information, i.e., that he is a relative by consanguinity or affinity as the case may be within the third civil degree. The court found that the information in Ubify only mentioned accused/appellant as the victim's uncle, without specifically stating that he is a relative within the third civil degree, either by affinity or consanguinity. Even granting that during trial it was proved that the relationship was within the third civil degree either of consanguinity or affinity, still such proof cannot be appreciated because appellant would thereby be denied of his right to be informed of the nature and cause of the accusation against him. Appellant cannot be charged with committing the crime of rape in its simple form and then be tried and convicted of rape in its qualified form. Thus, the Court of Appeals correctly disregarded the qualifying circumstance of relationship. Cause of accusation. 1. The allegations of facts constituting the offense charged are substantial matters, and an accused's right to question his conviction based on facts not alleged in the information cannot be waived. No matter how conclusive and convincing the evidence of guilt may be, an accused cannot be convicted of any offense unless it is charged in the information on which he is tried or is necessarily included therein. To convict him of a ground not alleged while he is concentrating his defense against the ground alleged would plainly be unfair and underhanded. The rule is that a variance between the allegation in the information and proof adduced during trial shall be fatal to the criminal case if it is material and prejudicial to the accused, so much so that it affects his substantial rights. Trudeau v. People. 2. In informing the accused of the cause of accusation against him, it is not necessary to employ the words used in the statute alleged to have been violated. It is sufficient for the complaint or information to use ordinary and concise language sufficient to enable a person of common understanding to know the following. Section 9, Rule 110. A. The offense being charged. B. The acts or omissions complained of as constituting the offense, and C. Disqualifying and aggravating circumstances. What determines the real nature and cause of the accusation against the accused is the actual recital of facts stated in the information or complaint, and not the caption or preamble of the information or complaint, nor the specification of the provision of law alleged to have been violated, they being conclusions of law. Nombrefia v. People. 3. The acts or omissions complained of must be alleged in such form as is sufficient to enable a person of common understanding to know what offense is intended to be charged and enable the court to know the proper judgment. The information must allege clearly and accurately the elements of the crime charged. What facts and circumstances are necessary to be included therein must be determined by reference to the definition and elements of the specific crimes. The purpose of the requirement of alleging all the elements of the crime in the information is to inform an accused of the nature of the accusation against him so as to enable him to suitably prepare for his defense. Another purpose is to enable the accused, if found guilty, to plead his conviction in a subsequent prosecution for the same offense, Serapio v. Sandiganbayan. 4. The accused will not be convicted of the offense proved during the trial if it was not properly alleged in the information. If the information charges a violation of a law, Section 3, Paragraph 2 of PD number 1613, that requires an intentional burning of a house or dwelling but the same information does not allege that there was an intentional burning of such dwelling, there cannot be a conviction under the said law because of an insufficiency in the allegations of the information. The failure to make the required allegations is fatal to a charge of arson under the applicable law, Villalobos v. People. 5. In another case, the victim was raped by the accused while she was under the custody of law enforcement authorities who were members of the PNP-CIDG at the time of the rape. Under Article 266b of the Revised Penal Code, the penalty for rape committed through force and intimidation is reclusion perpetua. The same provision also states that the death penalty shall be imposed if the victim was raped while under the custody of the police authorities, or when the rape is committed by any member of the Philippine National Police, PNP, or any law enforcement agency. This circumstance was not, however, specifically alleged in the information. The court held that it cannot therefore be appreciated even if subsequently proved during the trial. The RTC, ruled the court, was correct in imposing only reclusion perpetua. 6. Both the circumstances of the minority and the relationship of the offender to the victim, either as the victim's parent, ascendant, step-parent, guardian, relative by consanguinity or affinity within the third civil degree, or the common law spouse of the parent of the victim, must be alleged in the information and proved during the trial in order for them to serve as qualifying circumstances under Article 266b of the Revised Penal Code. In the case at bar, although the victim's minority was alleged and established, her relationship with the accused as the latter's daughter was not properly alleged in the information, and even though this was proven during trial and not refuted by the accused, it cannot be considered as a special qualifying circumstance that would serve to increase the penalty of the offender. Under the 2000 Rules of Criminal Procedure, which should be given retroactive effect following the rule that statutes governing court proceedings will be construed as applicable to actions pending and undetermined at the time of their passage, every information must state the qualifying and the aggravating circumstances attending the commission of the crime for them to be considered in the imposition of the penalty. Since in the case at bar, the information did not state that the accused is the mother of the victim, this circumstance could not be appreciated as a special qualifying circumstance. She may only be convicted as an accomplice in the crime of simple rape, which is punishable by reclusion perpetua, People v. Tompas. Similarly, in People v. Mejia, the qualifying circumstance of minority which was not alleged in the information was appreciated by the trial court in convicting the accused of rape. Sustaining the Court of Appeals which disregarded the qualifying circumstance, the court ruled that the said circumstance cannot be considered in fixing the penalty because minority, though proved, was not alleged in the information. As regards relationship, the same was alleged and proved. Pursuant, however, to Article 266b of the Revised Penal Code, in order to fall within subparagraph 1 of said provision, both circumstances of minority and relationship must be alleged in the information. The twin circumstances of minority of the victim and her relationship to the offender must concur to qualify the crime of rape. In the instant case, only relationship was duly alleged and proved. The court clearly explained. Jurisprudence dictates that when the law specifies certain circumstances that will qualify an offense and thus attach to it a greater degree of penalty, such circumstances must be both alleged and proven in order to justify the imposition of the graver penalty. Recent rulings of the court relative to the rape of minors invariably state that in order to justify the imposition of death, there must be independent evidence proving the age of the victim, other than the testimonies of prosecution witnesses and the absence of denial by the accused. A duly certified certificate of live birth accurately showing the complainant's age, or some other official document or record such as a school record, has been recognized as competent evidence. In the instant case, we find insufficient the bare testimony of private complainants and their mother as to their ages as well as their kinship to the appellant. We cannot agree with the Solicitor General that appellant's admission of his relationship with his victims would suffice. Elementary is the doctrine that the prosecution bears the burden of proving all the elements of a crime, including the qualifying circumstances. In sum, the death penalty cannot be imposed upon appellant. 7. In People v. Bigino, where the qualifying circumstances of relationship was not properly pleaded, the accused was not convicted of rape in the qualified form. The failure to so allege such relationship means that the accused was not properly informed of the nature and cause of the accusation against him. The main purpose of this requirement is to enable the accused to properly prepare for his defense, and he is presumed to have no independent knowledge of the facts that constitute the offense. 8. In another case, the information charging the petitioners with violation of R.A. Number 6539, as amended, did not allege that the carnapping was committed by means of violence against, or intimidation of, any person, or force upon things. The court emphasized that while these circumstances were proven at the trial, they cannot be appreciated because they were not alleged in the information. Thus, the lower courts erred when they took these circumstances into account in imposing the penalty, which they pegged at 17 years and 4 months to 30 years imprisonment. In the absence of these circumstances, the charge against the petitioners is confined to simple carnapping, whose imposable penalty should have been imprisonment for not less than 14 years and 8 months, and not more than 17 years and 4 months, Andres vs. People. How to state the date of the commission of the offense. 1. Section 11 of Rule 110 establishes the general rule that it is not necessary to state the precise date the offense was committed, because the offense may be alleged to have been committed on a date as near as possible to the actual date of its commission. 2. The same rule provides by way of exception that it is necessary to state the precise date the offense was committed when it is a material ingredient of the offense. 3. Section 6 of Rule 110 of the Revised Rules of Court provides that an allegation of the approximate date of the commission of the offense will suffice, while Section 11 of the same rule provides that it is not necessary to state in the complaint or information the precise date the offense was committed except when it is a material ingredient of the crime. People v. Estrada, People v. Fraganti. Duplicity of the offense, Bar 2005. 1. The general rule is that a complaint or an information must charge only one offense. More than one offense may, however, be charged when the law prescribes a single punishment for various offenses. Section 13, Rule 110. 2. An objection must be timely interposed whenever a complaint or information charges more than one offense. Failure of the accused to interpose an objection on the ground of duplicity of the offenses charged in the information constitutes waiver. People v. Tabio. When 2 or more offenses are charged in a single complaint or information, the accused must object to such fact before trial. If he does not so object, the court may convict him of as many offenses as are charged and proved, and impose on him the penalty for each offense. Section 3, Rule 120, Rules of Court, People v. Ching. 3. There should also be no problem in convicting an accused of 2 or more crimes erroneously charged in one information or complaint, but later proven to be independent crimes, as if they were made the subject of separate complaints or informations. As worded, the information sufficiently alleged all the elements of both felonies. Needless to state, appellants failed, before their arraignment, to move for the quashal of the information, which appeared to charge more than one offense. They have thereby waived any objection thereto, and may thus be found guilty of as many offenses as those charged in the information and proven during the trial.
Part 6. Venue of criminal actions.
1. As a rule, the criminal action shall be instituted and tried in the court of the municipality or territory, a. where the offense was committed, or, b. where any of its essential ingredients occurred. This rule is, however, subject to existing laws. Section 15a, Rule 110, Rules of Court. 2. In cases of written defamation, whether the offended party is a public official or a private individual, the criminal action may be filed in the court of first instance, now RDC, of the province or city where the libelous article is printed and first published. There are, however, additional venues. If the offended party is a private individual, the action may also be filed in the CFI, now RDC, of the province where he actually resided at the time of the commission of the offense. If the offended party is a public officer holding office in Manila at the time of the commission of the offense, the action may be filed in the CFI, now RDC, of Manila. If the public officer holds office outside Manila, the action may be filed in the CFI, now RDC, of the province or city where he held office at the time of the commission of the offense. Agbayani vs. Sao, 178 Philosophy 579, Foz, Jr. vs. People. Thus, if the criminal information is filed in the place where the defamatory article was printed or first published, then the information must so state that the libelous material was either printed or first published in the place of the filing of the information. Merely alleging that the paper or magazine is of general circulation in the place where the action is instituted does not confer territorial jurisdiction upon the court. A conviction under this kind of information should be set aside for want of jurisdiction. 3. In one case, an information for written defamation was filed in Iloilo City, but the information merely alleged that the newspaper where the alleged defamatory article appeared had considerable circulation in the city of Iloilo and throughout the region. The court ruled that the allegations did not establish where the said publication was printed or first published, Foz, Jr. vs. People. Similarly, in another case, the information filed in Manila merely alleged that the defamatory article was published in Smart File, a magazine of general circulation in Manila. A perusal of the information, explained the court, show that the allegations did not establish the printing of the magazine in Manila where the criminal action was instituted, Chavez vs. Court of Appeals. Also, an information which merely alleged that the libelous article was published in the Philippine Daily Inquirer, a newspaper of general circulation in Baguio City, did not sufficiently show Baguio City to be the proper venue of the printing and first publication of the newspaper, Augustin vs. Paminchuan Rule. Where offense is committed in a train, aircraft, or vehicle. Where an offense is committed in a train, aircraft, or vehicle, whether public or private, the criminal action shall be instituted and tried in the court of any municipality or territory where such train, aircraft, or other vehicle passed during its trip, including the place of its departure and arrival. Note that this rule applies when the offense is committed in the course of the trip of the train, aircraft, or vehicle, Section 15b, Rule 110. Rule. Where offense is committed on board a vessel. Where an offense is committed on board a vessel, the criminal action shall be instituted and tried in, a. the court of the first port of entry, or, b. of the municipality or territory where the vessel passed during its voyage. This rule applies when the offense is committed during the voyage of the vessel and is subject to the generally accepted principles of international law, Section 15c, Rule 110. Rule. When the offense is covered by Article 2 of the Revised Penal Code. Crimes committed outside the Philippines but punishable under Article 2 of the Revised Penal Code shall be cognizable by the court where the criminal action is first filed, Section 15d, Rule 110. How to state the place of the commission of the offense. The statement of the place of commission of an offense is sufficient if it can be understood from the allegations of the complaint or information that the offense was committed or some of its essential elements occurred at some place within the jurisdiction of the court, Section 10, Rule 110. Where the particular place where the offense was committed is, however, an essential element of the offense or is necessary for its identification, it is implied from the rule that the description of the place of commission of the offense must be specific.
Part 7. Amendment or substitution of the complaint or information.
Amendment of the information or complaint before plea, no need for leave, Bar 2001, 2002. If the amendment is made before the accused enters his plea, the complaint or information may be amended in form or in substance, without the need for leave of court, Section 14, Rule 110. When leave of court is required even if the amendment is made before plea. 1. Leave of court is required even if made before plea if a. the amendment downgrades the nature of the offense charged, or b. the amendment excludes any accused from the complaint or information, Section 14, Rule 110. 2. Aside from leave of court, the above amendments require a motion by the prosecutor, with notice to the offended party, Section 14, Rule 110. 3. The court is mandated by the rule to state its reasons in resolving the motion of the prosecutor and to furnish all parties, especially the offended party, of copies of its order, Section 14, Rule 110, Rules of Court. Rule as to amendment made after the plea of the accused. 1. If the amendment is made after the plea of the accused and during the trial, any formal amendment may only be made under two conditions, namely, a. leave of court must be secured, and b. the amendment does not cause prejudice to the rights of the accused, Section 14, Rule 110. Since the rule makes reference only to a formal amendment after the plea, the phraseology of the rule seems to indicate that an amendment in substance is, as a rule, clearly not allowed at this stage. 2. In a case, however, the court held that before the accused enters his plea, a formal or substantial amendment of the complaint or information may be made without leave of court. After the entry of plea, only a formal amendment may be made but with leave of court and if it does not prejudice the rights of the accused. After arraignment, a substantial amendment is proscribed except if the same is beneficial to the accused, Recoletos vs. Court of Appeals. When an amendment is formal or substantial, Bar 1997. 1. Thus, it has been held that the test as to whether a defendant is prejudiced by the amendment is whether a defense under the information as it originally stood would be available after the amendment is made, and whether any evidence defendant might have would be equally applicable to the information in the one form as in the other. An amendment to an information which does not change the nature of the crime alleged therein does not affect the essence of the offense or cause surprise or deprive the accused of an opportunity to meet the new averment had each been held to be one of form and not of substance. Thus, the substitution of the private complainant is not a substantial amendment where the substitution did not alter the basis of the charge in both informations, nor did it result in any prejudice to the other party. More so if the documentary evidences involved in the case remain the same, and all are available to the other party before trial, Recars v. Court of Appeals. 2. On the other hand, the following have been held to be mere formal amendments. 1. New allegations which relate only to the range of the penalty that the court might impose in the event of conviction. 2. An amendment which does not charge another offense different or distinct from that charged in the original one. 3. Additional allegations which do not alter the prosecution's theory of the case so as to cause surprise to the accused and affect the form of defense he has or will assume. 4. An amendment which does not adversely affect any substantial right of the accused, and 5. An amendment that merely adds specifications to eliminate vagueness in the information and not to introduce new and material facts, and merely states with additional precision something which is already contained in the original information and which adds nothing essential for conviction for the crime charged. Recars v. Court of Appeals. 3. One case which illustrates the distinction between a formal and substantial amendment particularly well is Pacoy v. Judge Ifabel Cahigal. Here, upon arraignment, the accused, duly assisted by counsel de part, pleaded not guilty to the charge of homicide. However, on the same day and after the arraignment, the respondent judge issued another order directing the trial prosecutor to correct and amend the information to murder in view of the aggravating circumstance of disregard of rank alleged in the information which the judge considered as having qualified the crime to murder. Acting upon such order, the prosecutor entered his amendment by crossing out the word homicide and instead wrote the word murder in the caption and in the opening paragraph of the information. The accusatory portion remained exactly the same as that of the original information for homicide. On the date scheduled for the rearraignment of the accused for the crime of murder, the counsel for petitioner objected on the ground that the latter would be placed in double jeopardy, considering that his homicide case had been terminated without his express consent, resulting in the dismissal of the case. As the accused refused to enter his plea on the amended information for murder, the public respondent judge entered for him a plea of not guilty. One of the issues sought to be resolved in the Supreme Court was whether or not the amendment from homicide to murder is a substantial one. In resolving the issue, the court ruled that the change of the offense charged from homicide to murder is merely a formal amendment and not a substantial amendment or a substitution. The court ratiocinated that while the amended information was for murder, a reading of the information shows that the only change made was in the caption of the case, and in the opening paragraph or preamble of the information, with the crossing out of word homicide and its replacement by the word murder. There was no change in the recital of facts constituting the offense charged or in the determination of the jurisdiction of the court. The averments in the amended information for murder are exactly the same as those already alleged in the original information for homicide, as there was not at all any change in the act imputed to the accused. Thus, the court found the amendment made in the caption and preamble from homicide to murder as purely formal. Section 14, Rule 110, explained the court also provides that in allowing formal amendments in cases in which the accused has already pleaded, it is necessary that the amendments do not prejudice the rights of the accused. The test of whether the rights of an accused are prejudiced by the amendment of a complaint or information is whether a defense under the complaint or information, as it originally stood, would no longer be available after the amendment is made, and when any evidence the accused might have would be inapplicable to the complaint or information. Since the facts alleged in the accusatory portion of the amended information are identical with those of the original information for homicide, there could not be any effect on the prosecution's theory of the case, neither would there be any possible prejudice to the rights or defense of petitioner, Pacoy v. Cahigal. Substitution of complaint or information, Bar 2002. 1. A complaint or information may be substituted if it appears at any time before judgment that a mistake has been made in charging the proper offense. In such a case, the court shall dismiss the original complaint or information once the new one charging the proper offense is filed, provided the accused will not be placed in double jeopardy. Section 14, Rule 110. 2. The dismissal of the original complaint or information is subject to the provisions of Section 19 of Rule 119. Under this provision, if it becomes manifest at any time before judgment that the accused cannot be convicted of the offense charged or of any other offense necessarily included therein, as when a mistake has been made in charging the proper offense, the court nevertheless shall commit the accused to answer for the proper offense by requiring the filing of the proper information. The accused shall not be discharged if there appears good cause to detain him. After the proper information is filed, it shall dismiss the original case. Distinction between substitution and amendment, bar 1994. The pronouncements in Pacoy v. Cahigal citing T. Honky v. Madiag, which distinguish between amendment and substitution under Section 14 of Rule 110, are illuminating. The first paragraph provides the rules for amendment of the information or complaint, while the second paragraph refers to the substitution of the information or complaint. It may accordingly be posited that both amendment and substitution of the information may be made before or after the defendant pleads, but they differ in the following respects. One amendment may involve either formal or substantial changes, while substitution necessarily involves a substantial change from the original charge. 2. Amendment before plea has been entered can be effected without leave of court, but substitution of information must be with leave of court as the original information has to be dismissed. 3. Where the amendment is only as to form, there is no need for another preliminary investigation and the retaking of the plea of the accused. In substitution of information, another preliminary investigation is entailed and the accused has to plead anew to the new information, and 4. An amended information refers to the same offense charged in the original information or to an offense which necessarily includes or is necessarily included in the original charge. Hence substantial amendments to the information after the plea has been taken cannot be made over the objection of the accused, for if the original information would be withdrawn, the accused could invoke double jeopardy. On the other hand, substitution requires or presupposes that the new information involves a different offense which does not include or is not necessarily included in the original charge, hence the accused cannot claim double jeopardy. In determining, therefore, whether there should be an amendment under the first paragraph of Section 14, Rule 110, or a substitution of information under the second paragraph thereof, the rule is that where the second information involves the same offense, or an offense which necessarily includes or is necessarily included in the first information, an amendment of the information is sufficient. Otherwise, where the new information charges an offense which is distinct and different from that initially charged, a substitution is in order. There is identity between the two offenses when the evidence to support a conviction for one offense would be sufficient to warrant a conviction for the other, or when the second offense is exactly the same as the first, or when the second offense is an attempt to commit or a frustration of, or when it necessarily includes or is necessarily included in, the offense charged in the first information. In this connection, an offense may be said to necessarily include another when some of the essential elements or ingredients of the former, as this is alleged in the information, constitute the latter. And, vice versa, an offense may be said to be necessarily included in another when the essential ingredients of the former constitute or form a part